All right, good evening. This is Attorney Vincent Davis. We're having some technical difficulties there, but we've got them straightened out. And this is The Secret: How to Fight CPS and Win. Today is question and answer. So if you have questions, please go ahead and post them in the link. While we're waiting for some of those questions to be posted, I'm going to go ahead and play a couple videos of YouTube shorts that I like and I think that everyone should watch. So stand by. Trial is fast approaching. Are you and your attorney ready for the trial? Have witnesses been subpoenaed? Has exhibits been subpoenaed? Has the witness list been prepared? Has the exhibit list been prepared? Have the trial briefs been prepared? These are all questions that you need to know the answer to before you go to trial in any CPS case. CPS cases are just like other cases. There should be preparation, and you should sit down with your attorney, either in person, by phone, or Zoom, or something like that, and discuss the strategy for your case. Don't wait until the day of the trial to talk to your attorney. Be proactive. Contact your attorney by phone, text, email. Talk to your attorney. These are your children that we're talking about. Make sure that you and your attorney are prepared. Ask them, have the witnesses been subpoenaed? Ask them, are the exhibits ready to go and be introduced? Call me if you have. Let me give you some tips on how to talk to your prospective CPS attorney or even your CPS attorney when you speak to them in person or on the phone. The first thing you want to tell them is not a story of your case. Do not tell them that. Put a fence around the story of your case before you tell the story. Be ready to tell the attorney the posture of the case, where you're at in the case, the next court hearing, and what type of hearing it is. And then, if he or she has the time, you can tell the story of the case. A lot of times, the story has no impact on the different phases of the case. I know that sounds strange, but each phase in a CPS case is different from the previous phase. So what happened 2 phases ago may not be relevant now. Call me, 888-888-6582. All right, good evening. We had a guest scheduled, but she was having some technical difficulties. And so tonight we're going to do a true question and answer. Here we have Jackie. Says, I am desperate to get on your show and ask you questions. Jackie, if you can come on the show right now, I'll have the producer send you a link and you can come on and ask me questions. Anybody else that want to do that? Same thing. Just let us know in the comment section. Jackie says, my son is 2 years old and autistic and being abused physically and sexually by his father and has been placed with his father and taken from the projected parent. Okay, I don't know what that question is. Maybe Jackie is posting her email so we can send her a link. If anyone else has questions, okay, if you want to be on the show, give us your email. Anahi, give us your email. We'll send you a link and get you on the show right now. Or Grace is also posting her email address. If you don't want to post your email publicly in the comments here, you can go ahead and email Grace at vincentwdavis.com. Okay, Grace, here's an email right here. Jackie is at jacksgreta@yahoo.com. So Grace, please go ahead and send Jackie a link so that she can come on the show with us and ask us her questions. Is that the same email? Yeah, same email for Jackie. Anahi, if you want to do it, go ahead and email Grace or post your email here. We'll have you on next and you can ask your questions. Tonight is question and answer night. The guest we had was having some technical difficulties, so we're just going to do straight question and answer for you folks tonight. You can post your questions in the comments Or you can email Grace or post your email here. We'll send you a link to bring you on the show, and you can ask your questions there. Claire Sierra Jade says, I'd love to share my journey with CPS in my country and see if there's in my county and see if there's anything I've missed. Sure. Sierra, if you want to come on the show tonight or post your questions, go ahead. Hey, we sent an email to Jack's Greta, so hopefully you're checking your email right now, and you will click the link, and I'll bring you right on the show. Oh, that's Jackie. Jackie, we're waiting for you. We're waiting for you. We're doing question and answer night tonight. Go ahead and post your questions or send us your email. Send it to Grace or post it right here in the comment section, and we'll send you a link to join the show. Anahi, I still haven't seen your email, so hopefully you've posted or you've emailed Grace at vincentwdavis.com. Hey, Grace, Jackie says waiting for email, looking for in my spam. I'll try to send her a email as well. So I'm going to compose an email. All right. So hopefully, Jackie, you're getting that email address. In the meantime, anybody in the audience have a question and answer? Tonight is question and answer night. Any questions you have, I'll answer the questions. Just post them there in the comment section. I want to tell you guys a quick story. I'm in the middle of a trial in a CPS case. Cases in Northern California. And it's a case where the allegations against the parents, the allegations against my client, the mother, is, drug usage. And the allegations, the allegations against the father is that he knew or should have known. I'll get back to the story. Here's Jackie. Hey, Jackie, how are you?
Hi, good. How are you?
Good. So what's your question tonight?
So, man, I have a lot of questions. I've been watching a show and I've pretty much been taking notes and learning everything, from Idaho legislation law and, reading the Idaho CPS manual front and back. And so I thought that I had, I was, armed with the law and called my attorney, which I have had 4 attorneys who have all, well, I have to be careful because I don't want to get sued, but
Yeah, we're not going to mention any names.
Right. But most of my attorneys have all turned on me and sabotaged my case. And in the beginning of this, I had sole custody. $70,000 later, I haven't seen my son for 30 days. He's been physically being physically abused by his father since November, and I've been documenting all the abuse. The first CPS case with the cigarette burn, where his pediatrician
Wait. Hold on a second.
Sure.
Because you're about to launch into a long story, and that's okay. But it's question and answer night. So
Okay.
Ask me the question.
Okay. Then my main question would be, so I signed a safety order. I had an attorney. He sent me into this meeting with a CPS worker without being there, knowing that this meeting was going to happen, knowing that I had no idea what my rights were and that I could have just walked out. I should have just walked out of there with my son in tow. And they're saying that I'm a drug addict, which they said from the beginning, because my abuser has been saying that I'm a drug addict. And then, so basically, if I violate this safety order and I know for a fact they have no evidence of any kind of safety dangers or whatever, and I've taken the steps that I need to take in order to mitigate the drug issue by going into detox, signing up for my outpatient program, as well as getting into the residential that I have to wait to get into. And there's no safety dangers. Okay.
What's the question, Jackie?
If I take my son back from the lady who his godmother, which I signed the power of attorney over for safety monitor, because that was the only person I had instead of going into temporary foster care. She's not letting me see him, by the way. And he's autistic, and she can't provide him with the 30 hours of ABA therapy, so I'm going to take him.
Okay, well, would that be against a court order?
Nope, there's no court order. Nope.
So you don't have a CPS case because you signed a safety plan?
I signed a safety plan.
Okay. So if you do that, they will file a case against you,
For sure.
and 99%.
But if they don't have any evidence, then they can't.
Well, Jackie, I'm just telling you from what you've told me.
Right.
Okay. Here's the danger. Okay. And I was talking to a client about this today.
Okay.
A lot of people that aren't lawyers and have experience in these areas of law, like CPS, believe that the law is all that you need to know. Okay. And that's a false statement, because the law is made up of different parts. There's the substantive law, which you've probably been reading about. There's evidentiary law that you probably haven't even started reading about. There's procedural law that you haven't started reading about. And then there's probably some type of rules, state rules or local rules that you haven't read about. So out of, 5 or 6 things, you read one thing and you feel you're armed, ready to go.
Well, I read a lot more than that, but no.
But that's a huge mistake.
Okay.
Now, I don't know the lawyers that you had and what you paid them and all that kind of stuff. I don't know.
Check. They all took a check.
Okay. So, it's a dangerous strategy that you're trying. Now, do people that represent themselves ever win? The answer is yes. But it's like 1 out of 1,000. And if you could make a very bad situation worse. And I'm not sure that you should do that because you feel a certain way. Miss G's not here today, but one of the things that we talk about with respect to these cases is you have to control your emotions, right? And look, I get it. I'm a parent, right? I'm a parent, and I get it. They're taking your kid away from you, and you feel helpless, powerless, and your child's probably the most important thing in your life for all parents. Most important thing in your life. But this is going to be the most important case of your life. You don't want to do it and do things hastily. Okay? So I can only imagine how you feel, but don't make this bad situation worse. Talk to an attorney in your state.
Okay.
Get some really good advice, even if you don't like it, and take that advice.
What can I do about the godmother who is supposed to be my safety monitor, that is supposed to be being next to me parenting so that he's safe, and just took custody of him into her home and isn't letting me see him?
Okay, well, that your attorney can address with CPS, because obviously there are some rules and regulations about that.
Yeah,
Maybe the child needs to be moved to a different safety monitor. I don't know, but these are things that you have to consider. Don't let what the foster mother is doing control what you're doing, because that's a perfect setup for them and
I
for
know
you.
what she's trying to do, and she's putting a restraining order on me, saying she's in fear of me. And I think that what she's trying to do is she's hoping for the abandonment, in 6 months, then she can file for, and get that check.
You got to get an attorney and get, even if it's a paid consultation, like a 1 hour or 2 hour consultation.
Okay.
Get that attorney and listen to it.
Yeah.
But don't let your emotions control what you do. And if there's a safety plan and the safety plan calls for you not having the child, do not go and get that child.
It doesn't say that. It says that it says I can't be around him 48 hours after I've used. I have to go to a drug treatment program for which I've signed up for, and I cannot have him. Basically, I can't be around him for 48 hours after I use. That's
Okay.
it.
Well,
And clean. So, and I've been testing clean. So,
okay. Well, please, please, please consult an attorney,
okay,
because you could go from the frying pan into the fire, and then that's going to make things worse.
okay.
Okay. So, are you in a program, substance abuse program?
Well, I'm getting into one, but there's a waiting list.
Okay.
But I'm clean. So I went to detox. I got clean. I've been clean. And when I went to go test for CPS, they said I gave when I first gave them a sample, it was clean. And then I got a call from my CPS worker saying they got a clean and a dirty test. So I called the drug testing place and I recorded it and I said, "Hi, I'm just Jackie Nygaard. I'm calling to see if you could just let me know, how many samples I've given you." And they didn't want to give me the answer. And they said they couldn't give me that answer. But she could tell me how many times I've missed and how many times I haven't shown up. And so basically they're saying that the drug test was dirty, but clean at the same time. So what I need to do is somehow they're not giving me the record because I only gave one sample and that sample was clean. So now I'm going to be testing. I'm testing with my own place, a professional place, so that, because they don't have a deal with CPS or whatever.
Right. Do you see the bottom left-hand corner of the screen?
Yeah. Yep.
You see where it says free CPS report?
Yep.
Have you gone to that website?
I have not.
Okay, so after today or after the show, I want you to go to that website.
Okay.
Okay, freecpsreport.com.
Okay. How much would it cost to hire you?
Well, you and I would have to have a long talk about that because I don't know
Okay.
everything about your case.
Right.
You've been talking to me less than 10 minutes,
I know.
probably. Right.
But I'm watching you every day.
Okay. Well, I appreciate that.
Yeah,
I hope you liking and subscribing to my channel.
I am.
Okay.
Most
And
Yep.
there's another so there's a telephone number on here.
Okay.
Hold on a second. Let me find it.
I have that written down.
Okay, the 888-888-6582.
Yep, I
You
got
call
that.
that number,
Okay.
leave your name and your number, and
Okay.
either I or one of my assistants, maybe Miss G, will call you back.
I've spoken with Miss G.
Oh, you have? Okay,
Yeah.
we'll call the number and
Okay.
ask to speak personally to Miss G.
Okay.
If you don't ask my receptionist, I have 3 receptionists. If you don't ask the receptionist to, "Hey, I want to speak to Miss G,"
Okay.
they'll send you to somewhere else.
Okay.
To
Yeah,
another
she's
person.
on her show too, because I went into detail about my case with her.
Okay, very
Yeah.
good.
Yeah.
There is another,
She's a little firecracker.
that's an understatement there, Jackie. There's another website I want you to check out as well. Let's see, what is it? Hold on, let me find it. Yeah, here it is.
Okay.
Boom. SueCPS.info.
Yes.
Okay, go to that website as well. Check that out.
Thank you. I will most definitely be going to that website.
Okay.
Awesome. And so when this is all said and done, I'm going after the deputies that physically assaulted me and almost broke my arm in front of my son. And the CPS worker was there, so he's an accomplice. I mean, I'm going after everyone when this is done. So,
Okay.
yeah.
All right. Well, give us a call and see if we can try to help you, okay?
That would be wonderful. Thank you so much. Thank you.
Thank you for coming on the show, Jackie.
Yeah, thank
Bye-bye.
you.
All right, that was Jackie from Idaho, I think. Idaho. Anybody else have any questions you want to post, or you want to give us your email and we will send you a link and bring you on the show tonight? Here we have a question from Sierra Jade watching on YouTube. Sierra, make sure you like and subscribe to my YouTube channel. It says, what is the statute of limitations for filing a civil rights violation lawsuit in federal court? Generally, in California, it's 2 years. So if you're planning on filing a lawsuit, here in California, you have 2 years. Now, the question becomes 2 years from what? Gotta have a starting place, right? 2 years from the violation that you're claiming, all right? Um, a few weeks ago, a woman called me with a terrible story of how she was, how her rights were violated. The only thing was when we got to the end, I said, "When did this happen?" She said, "Oh, 5 or 6 years ago." Guess what? The statute of limitations would probably bar her, prohibit her, prevent her from bringing a lawsuit. So if you believe your rights are violated, talk to your attorney. Find a local guy or gal to talk about with. All right. Here's Harley Neff says, watching on YouTube. Harley, subscribe and like to the channel. Can you become a CASA volunteer if you previously lost custody of your own child? Question mark. But a lot of growing up has been done in my life. I'm not like I was 6 years ago. Harley, I don't know the CASA rules, but if you're in California, I would go ahead and apply. I would apply and they'll see, what they can do, or if there are any exceptions or exemptions from, previously losing custody. And I think it's going to depend on how you lost custody and whether you're in the what they call here in California the CACI index, child abuse central index. So if you lost custody just because some judge thought in a family law case your wife was a better parent than you, probably not, I would have to say. I think you could become a CASA. But if you had a child abuse case, that's going to be tough. But don't let me guess. You should go ahead and investigate that. Okay. Let's see. Sierra says, that's too bad because you can't necessarily sue the county. You're trying to get your kid back from, so that's the waiting game. Yeah, you're absolutely right, Sierra. It's they put you in kind of a trick bag there. Hey Sierra, my producer just sent me a message that we sent you we sent you an email. So come on the show. Come on the show and ask your questions. All right, we have Trent Dancy. Mr. Davis, not every person that gets involved in CPS is innocent. Trent, I'm well aware of that. I have realized that is not the point in court because of the process. Can you please explain the rule of law and how it works in court? Well, Trent, that is a complicated question because the rules of law vary from case to case and from module to module. Remember on prior probably shows I've said I personally divide up the CPS case into 5 or 6 modules, and each module has its own statutes, its own procedure, and its own evidentiary burdens. So I can't, that's not something I can easily ask. If you have something specific, maybe related to your situation, I can give you some information. But explain the rule of law, I could do a video on that for, 80 hours maybe. And unfortunately, we have 45 minutes. All right, let me go here. We have Laura. You're watching on YouTube. Good evening, Laura. Make sure you like and subscribe to our channel on YouTube. Can children choose to leave adoption at the age of 15 in Ohio? My children reached out to me. My therapist even said I should never have lost my children. Laura, I'm only licensed as an attorney in California. We don't have that rule in California. They may have it in your state. That's something that you're going to have to talk to a lawyer about that's licensed, to practice in Ohio. I will tell you this story, and I've now heard of at least 2 people that have done this. Um, Maybe 5, 6 months ago, we had a woman on this show, and she was from San Diego County, and her parental rights were terminated, and I think the adoption went through, and 5 years passed. She never gave up. She ended up getting her child back. I think it was this year or late last year, getting her child back and her parental rights reinstated. Now, Granted, the stars had to align the right way, and probably a little bit of luck involved. But for those people that say you can't get your child back, there's not a likelihood that that would happen, but it does happen. And if you're like Winston Churchill, never say die. Okay, Sierra says, would that be your reasons for a delayed lawsuit? The county you're ultimately wanting to sue is responsible for giving you back your child. It could be. It definitely could be, Sierra, a reason for delaying the lawsuit. Okay. All right. Jackie saying, I was about to write an email to my social worker mentioning that NASW and their code of ethics kind of hint to them that they are in violation of the code of ethics that the NASW enforces and can sanction a social worker if they get them back. Jackie, before you write a email to anyone, please talk to your lawyer. Hey, I'm going to play one more video because I have to take care of something here in the studio and I have to remove myself from the picture. Let's talk about this detention hearing. Stand by. I'll be right back. All right. These are my detention hearing tricks. Your first hearing before the juvenile court in a CPS case. The one thing that you have to remember is you have to remember to argue and to show that the social worker did not offer you services in order to prevent the detention and placement of your children in a foster home. The social worker has to prove two things at a detention hearing, at least in California, and I would guess in other states, but check with your attorney. The social worker has to show that, you're some type of substantial risk to the child. That's pretty hard to do, especially if this is a one-time incident or the problem has been resolved. But the other thing they have to do is they have to show that they offered you services that would prevent detention. Talk to your attorney before going. All right, I'm back. Here is Trent. Trent says, thank you for that information. In other words, you can tell me how I should behave myself in court as a parent trying to get my child back. Well, one of the things that you shouldn't do is you shouldn't be boisterous and, yell at the judge. I've seen that happen. So, just try to be a reasonable human being and show the judge some respect, whether you like the judge or not. We have to give respect to the court system and to the judge because that's how our society is, organized. So don't shoot yourself in the foot and act a fool in the courtroom. Oh, we have Sierra. Sierra, you made it on. Thank you for coming.
I did.
What state are you in?
I'm in Ohio.
Oh, you're in Ohio. No, she was from Idaho. The last young lady was from what city in Ohio are you in?
I'm in Cleveland, Ohio, Cuyahoga County.
Okay. I haven't been since COVID. Used to go to Cleveland once a year in June, every year for a conference. But anyway, so what's your question this evening?
So I've been on quite a journey with, it's not necessarily CPS, but it was JFS is what they would call it out here, who was involved in my case. And that case was closed. The paternal grandparents of my daughter came forward to file a motion to intervene. And then they were fighting me for custody at that point. So I lost. And after I was able to prove with independent testing 1 year of sobriety, I was able to get my custody back. So that time has come to pass. I'm ready to move forward. I have a motion pending with independent lawyer that I hired. And since March 9th, I've actually had over 197 documented unsupervised visits with my daughter since that time. And as soon as the grandparents found out that I was retaining custody or going petitioning the court, they alienated me from her. I haven't seen my daughter since. And now supposedly she's changed her mind where she wants to live. Going forward, I guess my question would be, yeah, I have an attorney, I have a decent motion prepared, but that's a pretty serious, parental alienation is pretty serious. And for my daughter to change her mind, that's pretty serious. Should I have anything in my back pocket to bring, like, to say in court about what they're doing to her, or?
Well, you might want to get a parental alienation expert. Usually these are PhDs and psychologists who will come and look at your case and can testify to when there has been parental alienation.
And I've tried, I've looked, I'm not having much luck finding one, but I'll keep
Have you
looking, I guess.
Google knows all. Have you used Google?
I did, yeah,
Okay, Google parental alienation expert.
okay.
Now, you might not find anybody in your town or in your city or in your county, but I'm sure in the whole state of Ohio, you'll find somebody.
Right.
Okay, how old is the child?
My daughter's 8.
Okay, yeah, that's the prime age where you can convince a child just about anything. In a few years,
Absolutely.
you won't be able to do that, but at that age, you would be able to do it. I remember when my kids were around that age, and at that point in time, my wife and I were talking about separating, and we had 2 kids, and I talked to them, and they were like, "No, we want to live with mommy." And I said, "Well, why?" And then they told me because mommy said this and that and blah blah blah.
Right.
What could I do?
Right.
Nothing. I just kept my mouth shut, and me and my wife, who's deceased now, we reconciled luckily. But yeah, I was really shocked how, but I see it all the time in court. But it was happening to me, and I was just really shocked how easy it is to convince a child of
Yeah.
something, especially that age.
Right.
Sometimes they're too young to convince them. They're really not smart enough, and then they get past this age, and then they're too defiant, right?
Right.
They're developing their personality, and defiance sometimes is part of that. And you can if you say A, they'll say B. Just
Yeah.
because.
And
So
and like you said, I believe my daughter's at that prime age where she's, got a boyfriend. She thinks is her boyfriend. She loves her school, and I understand that that would be hard for her to move and transfer schools. I get that. That's something I think that we could work through, though. I don't think that's a reason to, to not be able to raise my daughter. But the grandmother's, doing the boyfriend play dates and just to kind of get her hooked and reeled in. But it's unfortunate, but I don't think that an 8-year-old is really capable of making that decision anyways. So I'd be surprised if the court really looked too much into
unfortunate,
that, or
unfortunately, it's one of those things that we know at that age. That's not the law, but
right.
it plants a seed in your brain and in the judge's brain, you know, and
True. True.
it's not, I had a case like this, maybe about a year ago, and I told my client I'm going to have to call that kid as a witness, put on the stand, and really grill the kid, right? And I was serious because I'm trying to win for my client, and my client, after finding this out, calls me back a couple days later and says, "Mr. Davis, I don't want to do that, because I've heard, what lawyers do on cross examination, and they're just trying to win," which is true. She said, "But I'm scared that you will do more damage to my child. So if we
Yeah.
go through the case, and I don't want you to call the child as a witness,
Yeah.
and you know." So one of the things I did was I left the child on the witness list, and it was kind of a bluff, right? They
Right.
thought I was going to call the child, and eventually they settled, the case. But if the case had gone through, I wouldn't have called the child because my client directed me not to.
Right.
You know, so there's a big move here in California to not have kids testify at all. Which is, in my opinion, not good for the parents because what can happen
Agreed.
is a social worker could say, "Oh, little Johnny told me ABC," and
Right.
little Johnny never said that. And if you can't call the child as a witness, how are you ever going to know that little Johnny never said that?
Exactly.
And so they
I
do a
agree.
balancing test in California. Um, and I think the case law says you got to have some evidence to show testifying what would be detrimental to the child. A lot of people, I've seen this, all over California. A lot of people file these motions with just the declaration of the attorney, who's not a mental health professional, saying, "Oh, it would be bad for little Johnny to testify," and the motions end up being granted sometimes, right?
Yeah.
Judges are, I don't want to say. I think they're sometimes overly sensitive as to what will happen to a child as a result of, having to testify in a case. But, we can easily say, well, it may not be good if you have some, attorney cross-examining them.
Right.
Um, you know, so those are things that you
Yeah.
have to consider. Things you
Yeah.
have to consider. But you have an attorney, right?
I do. I
Okay.
do. And I
Okay.
just don't feel like sometimes they, I don't know, they get their money and it seems like, you're telling them the same things 4 or 5 times and it's kind of worrisome.
Yeah. I can see that. I see it happen a lot. Because you know sometimes because it's your child and your family, you believe in your heart of hearts that you care more about the case than anyone, including the attorney. But in 9 out of 10 times, and I know Miss G would disagree with me, but in 9 out of 10 times, most attorneys they're right there with you. Now they may not be crying about it, but they want to represent you. They want to win the case for you, and they want to keep families together,
Yeah.
right? So,
And I thought maybe I had the upper hand too because my attorney is a former prosecutor for the county
oh, that's
CPS
good.
case.
That's
It's
good.
CPS cases. So he's I think he's mindful of what's going on and so I thought I'd ask you about, proving the parental alienation because it's something that I think is going on. Um, you
Well,
know, well, I
it's
know it's
prob
going on.
it's probably going on, but here's the thing. How are you gonna prove it? You can't
Exactly.
prove it without an expert to
I agree.
explain to the judge all of these things happen, and judge, that's what we call parental alienation. Parental alienation is actually a form of abuse, a form of
It
emotional
absolutely is.
abuse.
That's
So,
right.
your the grandparents are probably scared and probably pulling out all the tricks. Now, I happen to know about that personal knowledge about this kind of stuff. I was raised by my grandparents
Yeah.
who did everything to keep my mother away. I mean, I love my grandparents. Well, they're not with us anymore, but I love them. But I didn't see my mother from the age of 3 to 20, 17 years.
Wow. And I heard you made a comment too that your mom was a good mom.
Yeah, yeah. But when people get divorced, people take sides, and
Yeah.
when people take sides, sometimes they go overboard, right? In their what they believe about someone, and all that kind of stuff. And then sometimes people are they're beaten into the ground.
Yeah.
So listen, families do strange things, especially to each other.
Yeah.
I'm not a psychologist, not a psychiatrist, can't tell you all the reasons why that happens, but you've seen it.
Yeah.
You've seen it before and you'll see it after.
Right.
Just people that you know in your own family.
Yeah.
There was some, not necessarily family, but sometimes a lot of crimes are committed against victims, and the perpetrator is someone they know, you
Right.
know, and in many cases, it's a family member.
Yeah.
I just got involved with a case right now where the family member is really trying to destroy, you know, the the mother and father's family with their children. And I try to get to the bottom to find out to see what is motivating this family member, and it's difficult. Sometimes it's, SHIT that happened 20 years ago
Yeah.
that somebody didn't get over. You just don't know. And unfortunately, when you go to court, CPS court, family law court, a lot of times the judge is not able to hear the full story
Right.
because it's not just what's going on now. It's what happened 10 years ago.
Yeah.
To really figure out people's motivations.
Right.
But, by the way, having an attorney that's an prosecutor for CPS,
Yes.
that's a good thing in my opinion.
Yeah. I thought so.
Yeah, it's a good thing.
I thought so too. And then quickly, I was actually coming onto the show when you were mentioning it. Would the defense of waiting to get your child back be reason enough for a postponed federal lawsuit?
No, they're separate and apart. They're different.
Okay. Because I'm nearing that time. Like it's probably within months, and I have a solid case that I wanted to bring to federal court against the county, but I haven't gotten my daughter back yet. So.
Right. Now, there are some arguments that the fact that you haven't gotten your daughter back postpones, or what they call tolls, the statute of limitations, right? In my humble opinion, you don't want to be in the position of having to argue that. Okay? File it on time. Don't put yourself in the position of being the recipient of a motion to dismiss your case because of the statute of limitations, because then you got to start arguing tolling and blah 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 and the accrual date.
Would you do that without getting your child back first?
Well, if the statute was about to run, you would have to.
Okay.
I don't know about in your state, but in California, if you file a case, say in state court, that doesn't mean that the lawsuit's going to start right then and there.
Okay.
Right. You have a little lead time. But hey, I'm involved in. I told you I just got involved with this case. The CPS case hasn't even started, and my client, and I think it's a good idea because of what happened. Each case is different. Wants to file the lawsuit now.
Oh.
Yeah. And that's not something I'm always, recommending, but in some cases I do.
Yeah.
I do. Well,
I
listen,
appreciate your time.
thank
so
you for
very
coming on and asking questions. Make sure you like and subscribe and keep watching. All right.
Amazing. Thank you so much.
Thank you. All right. We're coming towards the end of the show. Here, let me put this up. Sierra, can you send me your attorney info? I need to get some help with custody of my young cousins. Sierra, I hope you hear that and see that. And that's Shashiwa. Okay, 42 USC 1983. What's going on, 42? Where you been? Can CPS be sued for/be guilty of bias and aiding a criminal party if they stay in contact with them while preventing investigations for that same party's alleged offenses? I would have to say in California, yes. I'd have to say under 42 USC 1983, the General Civil Rights statute, yes. Sierra says, send it where, Vincent? Okay, there's somebody who's watching. Oh, you're watching on YouTube, so you can't see the post from Facebook. Sierra, there is someone on Facebook. Her name is Sashua. As a matter of fact, Sierra, if you could just post your attorney's name and maybe his website before the end of the show, that might help Sashua who's watching on Facebook and can't see your comments in writing. Okay. Carol, how are you, Carol? Carol says, "Can I write the judge a letter?" Carol, you're not supposed to. It's called an ex parte communication, and if you do write the judge a letter, he or she is not supposed to read it. Okay? So let's not write the judge a letter and get in trouble. If you want anything told to the judge, you got to talk to your attorney about how we do that properly. Carol also says we're all in this together. You got that right, Carol. All right. Lloyd says, watching on YouTube, Lloyd, like and subscribe, my man. I posted a question, Attorney Davis, above. Okay. Let me try to find it. There's actually a lot of questions here. Okay, here, I think we found it, Lloyd. Attorney Davis, can you please give an example of how winning the appeal from the juris dispo did not help and the opposite of increasing the chances of winning in a civil rights lawsuit? Well, Lloyd, it depends on the claim. Okay, the claim that you're making. Sometimes, even if you win on appeal and the case is thrown out, doesn't mean that the social worker acted improperly or acted in terms of violating your rights. So, under most laws in California and under the federal law, you have to prove more than mere negligence. And maybe what she did was just purely negligent. Okay. You have to prove some type of an intent for malicious conduct. Okay. Let me give you an example of the two. Malicious conduct would be considered the social worker intentionally lying to the court in a report or on the witness stand. Okay. You can sue the social worker for that. Here's something you can't sue the social worker. The social worker made a mistake in writing the report and got said witness A said XYZ when they didn't really say it. They said XYA. Okay. And the social worker says, "Oh, I made a mistake." All right. Mistakes you can't sue social workers for under the civil rights laws. Okay. Now, I don't think the law should be that way, but it is. Okay. And one of the reasons why it is because states have passed these laws to protect their budgets. Social workers make mistakes all the time. And if everybody sued the social worker for a mistake, the counties and the states would go broke. So they made it a little bit harder for you to sue the social worker. And you have to show malicious intent or some type of fraudulent action like lying to the court. Okay, Lloyd, I hope that answers your question. All righty. Okay, folks. That is it for this evening, our question and answer. Lloyd says, "Thank you, Attorney Davis, for the elaborate answer." Oh, no problem, Lloyd. That's why we have these question and answer sessions. I want everybody to do me a favor, and after the show, go to this website, freecpsreport.com. That's one of my websites. And then to put the icing on the cake, go to this website, suecps.info. All right? Alrighty, folks. I want to thank everybody for watching tonight. We'll be on tomorrow night at 7 p.m. Pacific Standard Time. And we're on Monday through Friday, 7 p.m. Pacific Standard Time. And we're on the weekends at 9:30 a.m., both Saturdays and Sundays. If you guys want to be a guest and come on the show like we brought people on the show tonight, make sure that you email Grace, Grace, at vincentwdavis.com, and she'll send you a link and we'll bring you on the show. All right. You are quite welcome, Jackie. Jackie, don't forget to call me. All right. Don't forget to call 888-888-6582, and we'll talk about me helping you in Idaho. Alrighty, folks. Good night and have a good rest of the evening. Bye-bye.